This is the first session for Tuesday, June the 11th, 2019. Judge Kirkland presiding, appearing on behalf of the Office of the State Attorney
Kathy Kennedy Swanson.
and appearing on behalf of the Office of the Public Defender.
Cody Jordan with the Public Defender's Office.
Thank you. And the first case to be heard is,
Good morning, Your Honor. Michael Barber on behalf of Victor Gonzalez. He is
Thank you.
present to my right, Your Honor.
all right. Mr. Gonzalez, I'm Judge Kirkland. I'm reviewing your case as the initial appearance judge today. It is titled a warrant arrest affidavit, but it's actually a capias, which means to me there has been an information filed against you by the State Attorney's Office, and the charge was possession of controlled substance. But it indicates on this capias issued by the clerk on behalf of the judge, failure to appear for arraignment on June the 6th. So 5 days ago, it indicates you did not appear for an arraignment. And that judge in Division 15 has indicated no bond, meaning you must appear in front of that judge for the judge to decide what to do next. And so I'm simply advising you of that, and you have an attorney. So your next step is to see what the judge in Division 15 determines.
Thank you very much, Your Honor.
One other thing. One other thing, don't let him, what is the state's position with regard to the hold that the jail has for a prior case?
No action.
Okay, at this time, then, I take no action, and the hold that the jail has for him is now lifted, all right?
Thank you, Judge.
ROR's count 2 on the way. Cody.
This is Floyd Foster Halliburton.
Yes, sir.
Good morning, Mr. Halliburton. I saw you yesterday.
Yes, sir.
And at that time, I did find probable cause on a city ordinance violation of camping, and I appointed the public defender to represent you. And you indicated that, you
Sorry, I can't hear what you're saying, sir.
all right, we will get you some assistance on that. We'll get you some hearing assistance. The charge that's before me is a city ordinance violation entitled camping or being in a location where sleeping is not allowed. In this particular case, it was Lake Eola Park on a bench that's designed for people to sit, and it was alleged that you were laying or lying on the bench, and that the characteristics were of a person sleeping. And you began a plea process, but ultimately you determined that you felt like it was more important to you to have a trial to try to get settled the issue of whether that city ordinance is constitutional, whether it's appropriate. And so today's issue is, do you think it's better for you to enter a plea to resolve the case and be released today, or do you think it's better for you to contest the case so that the matter that's important to you can be resolved by a jury? And so have you had an opportunity to talk with your public defender about those options?
No, I have not.
Okay, I'm going to give you that opportunity right now.
After speaking with my client, he does not wish to resolve either case today.
Thank you.
Bond? Is there a bond in this case?
I believe it was 250.
$250.
Thank you, Your Honor.
This is Gabriel Aaron Clements. And it is spelled with a K, or Kelmets, Kelments, is that correct?
Well, sir, they made multiple stakes on my last name. So,
How do you say your last name is correctly spelled?
well, from what I've heard, it's Klements.
Okay. And that's what you have always used is KLE, Clements?
Yes, sir.
Thank you. So it should be noted that he is charged today as Gabriel Aaron Kelments, Kelments, and I have to agree that I've never seen that particular name ever, but if the L and the E were reversed, it would be more likely. But we will simply indicate that is what you have indicated is the correct name. It's a trespassing charge from the Orlando Police Department as a state charge. And you have not requested an attorney, but would you like to hear what is offered by the state attorney on behalf of the city today to resolve the case today?
Yes, sir. I would love that.
All right. What says the city concerning this issue?
Adjudication credit for time served.
Would you say that again?
Adjudication credit for time served.
Thank you. Whenever this machine over here is going.
Understand, Judge.
It's a block right about here. The offer is, if you decide it's in your best interest to enter a plea, it will be time served. And that, in this particular case, it looks as if that would be 2 days, credit for 2 days served. You'll be released later on today, and it's three days, that's correct. 3 days, credit for 3 days served, and I will order you not to return to that location.
Yes, sir.
Okay, you'll need to read and sign your plea form at this time.
Yes, sir. Yes, sir. No, sir. Yes, sir. Yes, sir.
Okay, we'll start out with, it sounds like we've already covered this, but this is important. What's your full legal name?
Gabe. It's Gabriel Aaron. And honestly, I don't know my last name.
Okay.
He's never given anything. Everything's been stolen from me, from my social to birth certificate.
What-
Obviously, they're putting wrong
what-
names on
what-
my license.
What is your date of birth?
4195,
Thank you.
I reckon.
Thank you. Well, that's something a person doesn't forget. So
Yeah.
one of the reasons that's asked is to make sure you're the same person we think you are, and also to make sure that your head is clear and you understand what's going on. I don't want to try to take a plea for someone that's confused or perhaps under the influence of something that's interfering with their ability to make a reasonable decision today. So you feel that you've had enough time to decide what's best for you? Or do you need more time to think about it, is what I'm getting at?
Yes, sir.
How do you plead? You can
plead-
plead no contest. You don't admit anything, but for convenience, you want to resolve the case today and be released from jail.
Yes, sir. Guilty, sir.
Are you willing to stay away from that location, 109 East Church Street?
Yes, sir. That's just the church itself, right? That doesn't mean the whole street.
It actually does not say in here, in the paperwork what is involved, but my memory tells me that's the downtown Baptist church.
Yes, sir.
All right. And so my memory tells me there's a sanctuary on the corner of Church Street and Magnolia. And next to it is another building that's used for general purposes. Those two and there's an alleyway in between the two. It would cover all of that. If there's something west of there that's another business, which I think is likely on the corner, that would not be a part of that. Just stay away from that church.
Yes, sir.
All right, I'll accept the plea at this time. You're adjudicated guilty. It's time served. It's 3 days, credit for 3 days served. The court costs will go into a civil judgment, meaning sometime in the future, if you're ever able to pay it, it's sitting there, but it will not affect your ability, your being released today. And I order that no return is during the next 177 days. All right? You'll be released today.
Yes, sir. Thank you, sir.
This is Kelvin Carl Webb next.
Oh, okay, I'm sorry. Good morning, Your Honor.
Good morning. This is, I'm Judge Kirkland. I'm Judge Kirkland. I'm reviewing your file here. It says that the charge is possession of cannabis less than 20 grams.
Excuse me, sir.
Just a moment. Is that your name, Kelvin Carl Webb?
Yes, sir.
All right. And would you like to have an attorney assist you in this case?
Yeah, you can have somebody assist me, yes.
Would you like the public defender to represent you?
Well, they told me because of, no,
Can you afford a private?
I don't want to pay for an attorney.
Okay.
But, Your Honor,
I'm gonna allow Mr. Jordan that's standing next to you to assist you if you want him to assist you. But the charge is one that perhaps there's an offer to resolve the case today.
Oh, withhold credit for time served.
All right. The offer on this case is to withhold adjudication, so you would not have a criminal record from this case. Time served, you'll be released today, and I will indicate that you have 350 days from today to pay the court costs. So you want to give that some thought as to whether that's better for you or to try to bond out?
Your Honor,
I'm sorry.
after speaking with the defendant, he does wish to take the offer and enter a plea of no contest.
Thank you.
Yeah, I'm sorry, Your Honor, I didn't mean to, no, I ain't had my medication.
I understand.
No, I don't disrespect no Your Honors and shit. For real, I don't.
This was just an
Well, I understand that I see a lot of people, and no one is identical to anybody else. And I
Exactly.
recognize some people act very calmly, and some people are perceived as being the opposite. And that, you seem to be jumping. I just want to make sure that that's more of your nature than being, you're not under the influence of something that's making you do that. Is that correct?
Yes, sir, I haven't had my medication 2-3 days.
Okay. What I want to make sure, though, is that you're able to think clearly. Do you believe that you're able to make a good decision today?
Yes, sir.
Okay. How do you plead to the charge of possession of cannabis less than 20 grams?
Oh, no contest.
Okay. And have you had enough time to decide what's best for you to do today?
Yes, sir.
And did you read and sign this plea form?
Yes, I did, Your Honor.
Okay. I'll accept the plea at this time. It's a withhold of adjudication, 3 days, credit for 3 days served. I note by reading the narrative of the charge, it states that you also received a ticket for going 75 and a 55 on 441 up near Apopka, and you're from Mount Dora, I understand?
Yes, sir.
Okay. Make sure that you pay that so that I don't see you coming back for,
For the
For-
ticket?
you don't want to get your license suspended for not paying the
The
traffic ticket.
Oh, okay.
So make sure it's in your personal effects.
Yes, sir.
Don't lose it, make sure it gets paid.
Yes, Your Honor, thank you.
The court costs in this case will be payable within 350 days from today. You'll be released later on today. You do not lose your driver's license because of this case, because I have withheld adjudication. You have not been convicted of this case.
Yes, sir, thank
All right.
you, Your Honor. Hey, you don't want to. Thank you.
This is Michael William Kirkland. Next. Are you Michael Kirkland?
Yes, Your Honor.
All right. There are 4 charges before me today. And my understanding is that you have been in the hospital, so this is the first opportunity to see you.
Yeah, I had been here and they wanted to bring me in, but I
All
explained to
right.
them.
Well,
and they took
I
me.
want to make sure that you know why you are being held. The charges are robbery with a deadly weapon, aggravated assault with intent to commit a felony, petty theft of $100 or more, and resisting a merchant. Those are 2 felonies and 2 misdemeanors. It's from 5734 South Orange Blossom Trail, which is a Walmart store, a big
Yes.
box store. The public defender is appointed to represent you today. This set of charges comes to me as a no bond case, but I will be setting the bond today. What's the state's position concerning the appropriate bonds on these charges?
Your Honor, based on his criminal history, state will request a $30,000 bond as to count 1. No objection to counts 2 through 4 being treated as subsidiaries. No contact with the victim, no return to the scene of the offense, no weapons, no firearms, no drugs, no alcohol.
What do you want me to do?
Do you have a record for me to review on that? I don't have it. Michael William Kirkland. Michael William Kirkland. We don't have a crime record. Thank you. All right. Having reviewed the allegations contained in the narrative of the arrest affidavit and having reviewed the prior record, I find the following would be the appropriate bonds on these charges.
I can't come back on a bond reduction or something.
Robbery with a deadly weapon will have a bond. That bond is set by me today at $10,000. Count 2 is a felony, bond 150. Count 3 is a bond of 100, and count 4 is a bond of 100. Therefore, the total bond is $10,350. Not to return to to the Walmart at 5734 South Orange Blossom Trail while this case is pending. Not to be in possession of any weapon, including a firearm, while the case is pending. To have no contact with anyone that is named or referred to as a victim or witness in this case. The public defender represents you in Division 15. Judge Dan Traver is the judge assigned to this case.
Did you have any questions about that? If you can't afford this bond, your attorney can file a motion for any draw or
Put
showing
it back. Here it is.
There's one thing that's a very serious charge. He's reduced it significantly.
I mean, possibility of what do you call it?
R1, release on your premises. No. That's,
Okay, so if anything,
your attorney needs to file a motion. Right.
yeah, well, if anything, if the attorney would like to get talk with him ASAP.
This is a serious case. You will have an attorney assigned to you as soon as possible, and we'll get in contact with you, sir.
Okay, to talk with him about it. And
But you need to talk with
possibly-
him at this point because
Okay.
for now,
To
the
get
initial
a
appearance is
bond
over.
reduction as well.
Right.
So if you could do that as soon as possible.
Right.
Thank you, Your Honor.
This is Michael Shane Posey. This is a charge of aggravated assault with a deadly weapon from the city of Ocoee. The address of the arrest was 908 Marlene Drive. That's also the address given for the event that's the subject of the case from yesterday, June the 10th. The bond is set at $2,500. The additional conditions not to return to 908 Marlene Drive while the case is pending, to have no contact with anyone that's named as a victim or witness in the case, not to be in possession of any weapon, including a firearm, while the case is pending. The public defender is appointed to represent you in Division 17, and I believe that's Judge Keith White. You can now bond out $2,500 bond.
Sir, I have some information for you. $1,500 bond. If you want to do bail bonds for Ron, you can go 10%.
This is Jason Goddard.
Your Honor, we're gonna give him a wheelchair. if he's
All
having
right.
issues.
Would it be best for me to return to this?
Return to- yeah.
All right. We'll come back to that case in a few minutes. I'll see instead Stephen Adams. Okay. What is your full legal name?
Stephen Adonis.
All right. This is Stephen Adames. It is an arrest affidavit from yesterday at World Center Drive and International Drive South. 3 charges: possession of cocaine with intent to distribute, possession of heroin, and possession of drug paraphernalia. The bond on the count 1 is $15,000, count 2, $150, count 3, $100. So the total bond is $15,250. I appoint the public defender to represent you in Division 15, that's Judge Dan Traver. I order that you not return to within 500 feet of the intersection of World Center Drive and International Drive South while this case is pending. I believe that's a Speedway gasoline station. And you're not to be in possession of any substance prohibited by law as a condition of release. You can now bond out on that bond of $15,250. This is Sean Barnett. Oh, I'm sorry. I'm returning now to Jason Goddard.
Good morning, sir.
Morning. I have two cases for you.
Yes,
One
sir.
is Orange County, one's Seminole County.
Yes, sir.
The Orange County case is a city ordinance violation from yesterday
Yes, sir.
at 512 East Washington Street.
Yes, sir.
It's a camping charge.
Yes, sir.
And that is Lake Eola Park Building
Yes, sir.
Porch. The bond is $250. There's also a hold for Seminole County,
Yes, sir.
and that is Judge Her, and it is a petty theft charge,
Yes, sir.
and the bond is $995
Yes, sir.
on that case.
Yes, sir.
You can bond out on either case,
Thank you, sir.
but if you resolve the Orange County case and you don't bond out, you'll be transported to the criminal building of South Seminole to see a judge there for a first appearance on that charge.
Yes, sir.
There may be an offer from the city to resolve this camping charge today.
Adjudication 3 days.
The offer is 3 days,
Yes, sir.
credit for 2. Ordinarily, you'd be released later on today, and then you'll go to Seminole County later on this week.
Yes, sir.
So, if you resolve that case, you get out tonight.
And I have appointed the public
I'm gonna
defender.
talk to the state real quick.
Yes, sir.
About that.
Yes,
But
sir.
you still, I can't do anything about your out-of-county.
I understand, sir.
Can you pay the bond on the out-of-county?
Yes, sir.
Okay, let me talk to the state real quick.
Okay.
Your Honor, can I have a moment to talk with the state?
And I also have the case number if you don't have it. Do you have the case number?
No, Your Honor.
Okay, it is 19MO1141.
Thank you, sir. I was in the hospital.
He needs to, he has to get to the hospital to deal with that infection. We're asking for time, sir.
3 days is the time. 10, 11, yes, but he gets it, he'll get outside. It won't matter, it's not gonna change the time, it's 4 to 6 hours process now.
Your Honor, after speaking with my client, he does wish to accept that offer and plead no contest as to 2019 MO 1141, a plea for a 3 days, credit for 2 days, time served.
Thank you.
Was the public defender appointed to that case, Your Honor?
Yes.
All right.
What is your full legal name
Jason Scott Goddard, sir.
and your date of birth?
December 8th, 1962, sir.
The charge before me is camping where prohibited, and it doesn't really describe necessarily the charge, what the real charge is,
Yes, sir.
but it has to do with just being in a location where it was designed for someone else.
Yes, sir.
How do you plead to that city ordinance violation?
Oh, sir, I'm very sorry about the misunderstanding. I plead
No
no contest, sir.
All right?
I'm sorry.
Do you have any questions you want to ask me about the charge, the facts of the case, the plea that you're entering, or the proposed sentence?
No, sir, I just say lesson learned. I'll learn from this. Thank you.
I'll accept the plea at this time. You're adjudicated guilty. It's 3 days, credit for 2. You'll be released later on today, and you'll go to Seminole County unless you bond out on that case.
Yes, sir. Thank you, sir.
I do order that you not return to that particular location of 512 East Washington Street, that no return would be during the next 178 days.
Yes, sir.
The court costs in this case go into a civil judgment.
Yes, sir.
Okay?
Thank you, sir.
Yes, sir?
You're very kind. God bless you. God bless America.
Thank you for your service.
That's my pleasure. I love my country. Ask anybody.
Okay, we're gonna back
Aim high, Air Force. Bye-bye.
back out this way.
Okay, thank you. God bless you. Thank you.
Sean Alvin Barnett is next, and that person's not before me. What do we know about Mr. Barnett?
Mr. Barnett is downtown court, Your Honor.
Okay. He'll be reset to be seen tomorrow by the first appearance judge here. It's a warrant, and it's no bond, so it doesn't change his, it doesn't affect his inability to be seen today. Reset. The next case schedule is Jameer Blyden.
Surety bonded, Your Honor.
Bonded?
Yes, sir.
Thank you.
Uh-huh.
Aricia Brock. This is a warrant that comes, a warrant affidavit. It's actually a capias. That indicates that in Division 12, an information was filed against you for aggravated assault with a deadly weapon, but the judge in Division 12 has ordered that you be held on a no-bond status based upon this capias, failure to appear for a trial management conference on May the 30th of 2019. So this is from about 2 weeks ago. Release was revoked at that time, and you're held without bond till you see the judge in Division 12. Do you already have a public defender in that case?
Yes, sir.
Okay, so the public defender in that case is who you will want to contact to get a hearing as soon as possible in front of the judge in Division 12 to see whether that judge will set new conditions of release.
Okay.
I'm going to get in contact with him as soon as possible. I don't have anything right now I can give you. I can give you this, but the actual lawyer, I'm going to look up and get their number to talk to, okay?
Okay.
Stephen A. Karstensen is the next case. Are you Mr. Karstensen? This is an arrest warrant. It's a warrant that comes from Division 11. The case number is 19 CF 8392. The charge is grand theft, third degree, and it refers to an incident on or about June the 9th, day before yesterday. The judge set the bond at $500, together with a condition of not to return to the scene of the event. The public defender is appointed to represent you in this case in Division 11. There is a second matter, and it is an arrest affidavit from yesterday. The public defender is appointed to represent you in Division 14 on the new charges from yesterday. There are 3 counts, and it is from 4750 Millennia Plaza Way. Count 1, possession of ammunition or an electric weapon by a convicted felon. The bond is $10,000. Count 2, retail theft, more than $300. Bond, $300. Count 3, possession of an anti-shoplifting device or inventory control device. bond set at $200. So there are 2 felonies and 1 misdemeanor. The standard bond for that convicted felon, I was under the belief that that was $4,000. Is that correct? The standard bond is $4,000? And it would be doubled due to the fact that he's not a Florida resident. But I'm not certain about that recently, what the standard bond might be on that
That's on the
case.
possession, Your Honor?
Possession of ammunition or a device by a convicted felon.
It's $4,000.
All right. The amount that's the appropriate bond for that case is therefore $8,000. It's doubled due to being an out-of-state resident and having no apparent close connections to Orange County.
Your Honor, I do believe he resides here. He's from Denver, but he currently resides here in Orlando. He does have an address. His fiancee has an address. If we could proffer that to the court, would you recognize his connection to the community through that address?
The options would be for you to, if he is willing to testify under oath as
Yes.
to his connections. Otherwise, he would have to apply to the judge in Division 14 for a reduction due to connections. So we'll have this defendant sworn in at this time.
Would you raise your right hand? Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes.
Sir, can you please state your name and spell it on the record?
Stephen Carstensen, StephenCarstenson.
Sir, where do you currently reside?
It's 6204 Cava Alta Way, I believe is what it is.
And is that located in Orlando, Florida?
Yes.
How long have you been staying there?
About 2 weeks.
And where did you previously live?
Denver, Colorado.
Okay, and do you plan on staying in Orlando?
Yes.
Do you have job or work here, or you plan to find work?
I've been looking for work. We came out here to visit her mom who's fallen ill,
I see.
and she decided she wants to stay here, and I'm just gonna stay with her because we're engaged.
Okay. Thank you. I have no further questions.
Was it your testimony just now that you are residing with your mother?
No. We came out here to see her mother who's fallen ill, and I'm staying with her brother. Me and her are staying with her brother.
All right. Does the state wish to ask any questions concerning the issue of connections with Central Florida?
No, Your Honor.
All right. At this time, I will change the bond in this case from $8,000 to $5,000.
Okay.
Yes, they remain the same.
And what is the total bond amount?
Okay. He has a $500 bond on the warrant. His bonds on counts 1, 2, and 3 from yesterday, $5,300, $200. So his total bond comes to $6,000 for 4 charges. The next case is Kenny Etienne. This is an arrest affidavit from yesterday, from 1758 Americana Boulevard. That is an apartment complex. It is an arrest affidavit that has 3 charges. Count 1, possession of methamphetamine. $1,000. 2 misdemeanor charges are next, possession of cannabis and possession of drug paraphernalia. Your total bond is $1,200. I appoint the public defender to represent you in Division 16. This case is complicated by the following. It is shown here that you were out on bond on a charge of driving while license suspended, a first-degree misdemeanor. Case number 2019 CT 3441AO. At this time, I revoke the bond in that case. Your new bond is $2,000 in that case. The second charge, or the second matter, is you were out on bond in Division 17 on 3 charges, and they are the same 3 charges as the new case. And that case number is 2019 CF 6562. It shows that you were arrested on May the 7th, 2019, and bonded out on May the 10th, 2019, on a $1,200 bond. I believe I am to take the following action on this case. I revoke your bond and I hold you on no bond, and the judge in Division 17 will have the opportunity to decide whether new conditions of release would be imposed or whether you will be held without bond because of the closeness in time of these charges and the fact that they're the same charges, while the driving while license suspended charge is not as crucial a case as the others. These are charges. The possession of meth charge from yesterday and from May the 7th are charges that I believe I am to hold you without bond until you see that judge. The public defender represents you on all of these cases.
Your Honor, we'd ask you to take no action, given the fact that charges have not been filed in the felony case. The minor matter in the traffic case is unrelated to the current charges. I would also note that he only has 2 failure to appears, his last failure to appear being last year, and the nature of these charges today, these are non-violent offenses. I would ask you to take no action on all of them.
I agree with that entire argument, except I've taken all of that into consideration, and I believe that the charges themselves, to me, are more important than the issue of failure to appear. That not appearing is not as crucial. People miss dates all the time simply because the calendar is not that easy. But it's very easy to keep from being in possession of meth, which is one of the more dangerous substances on earth. And so I believe that I am simply doing what is required of a first appearance judge. The judge in Division 17 may very well give a new bond, but that's up to that judge, who will analyze the philosophy of what happens when it happens twice in consecutive months. This is Juan Guillermo Florens.
Yes, sir. Good morning, sir.
This is a warrant arrest affidavit, and it indicates that Judge Allen found that on June the 1st of 2019, so this is from a week and a half ago, that you failed to register, and you're being held without bond. But I am to set a bond today, and that bond is to be based upon whether there are prior convictions of the same type of charge. What's the state's position concerning the appropriate bond on the charge today?
I believe it's $3,500, Your Honor. $3,500.
Okay? And that is based upon one prior?
I didn't see any priors, Your Honor. Hold on.
But generally speaking, my position is if he has no priors, if this is the first one, the standard would be 2,500.
I don't see any priors on his criminal history. I
All
see
right.
the original charge, but not
Okay.
failure to.
All right. I believe the appropriate bond in this case is $2,500. And this is for your benefit, and your attorney will assist you on this. Your present address by law is the jail. So when you are released, you are going to a new address, and therefore you must register as soon as you leave within the time period allowed by law.
Yes, sir.
And that's, I believe, the two locations. One is the driver's license office, and one is the sheriff's office. All right.
Yes,
Sir? He's right.
This is Tyree Jamon Hinton.
Yes, sir.
This is a failure to appear. Capias was issued in Division 22. The original charge was possession of cocaine, and it states here that there was a pretrial conference on August the 29th of 2018. So this is from about 9 months ago.
Yes, sir.
The judge in Division 22 forfeited your bond in order that you be held without bond till you see the judge in Division 22. Are you planning to hire a private attorney to represent you, or do you think it would be best to request a public defender to be appointed?
Public defender.
Okay, and so would I be correct then to assume that you would like the public defender to continue to represent you in this case?
Yes, sir.
All right. This is a public defender case in Division 22. Your next hearing will be in front of that judge.
Excuse me. Can I ask you when is the court date?
Well,
Right? Okay, sir.
I'm sorry.
we don't have one yet.
Sir.
Next case is Dominic Lee James. This is also a capias that comes from Division 22. The original charge is possession of a controlled substance and possession of drug paraphernalia. Failure to appear for a case management conference on September the 5th, 2018. So this is also a case from about 9 months ago. Release was revoked by that judge in Division 22, and you were being held without bond until you see that judge. Is this also a public defender case? So your public defender will assist you in your usual procedure would be to request a hearing as soon as possible in front of the judge in Division 22.
State agreed. Dropped.
Kelly Lee Lynn. This is an arrest affidavit from yesterday. I've appointed the public defender to represent you in Division 15, and here is the case number, 19 CF 8393. The case comes from the city of Apopka, Orange Blossom Trail and Boy Scout Road. Count 1, vehicle theft, grand theft of a motor vehicle. Count 2 is possession of a Schedule II drug.
Your Honor?
Yes.
I did have argument. I spoke with the state. I believe they agreed to ROR on count 2, given the fact that the co-defendant, the substance was found in the car, not in possession of any individual, and the co-defendant admitted to owning the substance.
All right. The second count that would ordinarily have a bond of $30,000 is now ROR, based upon the agreement reached between state and defense. Your bond on the first count is $2,000, so that's the total bond on this case, $2,000, but no contact with the co-defendant Jacob Daniel McMurphy while this case is pending. And number two, not to be in possession of any drugs prohibited by law while the case is pending. Stay in touch with your public defender in Division 15.
Your Honor, I do believe the co-defendants live together. Would it be possible to have on the record a one-time return to the residence?
Yes. My obligation is, even though there may be all sorts of connections between the parties, this is an appropriate one for the following, that if in fact there is a common residence, you can return one time with the appropriate, it will either be a police officer or a deputy, depending upon where it is, to get your clothing, personal effects, automobile, tools, whatever's involved. I'm not ruling who lives where, only that I am ordered to order you to have no contact with that person.
Here's some information. That's going to be, all right. So you can go back and look there if he's not there.
And Mr. Murphy is the next case.
Yes, Your Honor.
This is Jacob Daniel Murphy. Count one, in this case, is grand theft of a motor vehicle, and count two is Schedule 2, possession of substance prohibited by law. From the same time and place as announced on the other case, Orange Blossom Trail and Boy Scout Road in Apopka. It's an appointment of the Public Defender in Division 14, case number 19 CF 8394. Clearly, this is a case in which the public defender will ultimately not be able to represent both of these two persons. There will be another attorney that will represent one of the two of you, and then the public defender's office will represent one of you. The appropriate bond in this case is as follows. On the first charge, the grand theft, it's a $2,000 bond, and on the second case, it is a $30,000 bond. Now, if in fact that remains the same, the first bond will become a bond of $300. And I'm doing that at this time, so the total bond would be $30,300. It's an unusual amount, and as are many of these types of cases, but under the rules at first appearances locally, the bond is to begin at what is the minimum fine if a person is convicted on the charge. On the Florida statutes, that is the fine if, after the case is completed, if you are actually convicted on the case, there is a mandatory fine of $30,000, and so that's the bond to get out initially. Furthermore, if you're able to post that bond, I believe that the judge assigned to the case would determine that you no longer can be represented by the public defender or another case or another attorney other than a private attorney. It would show that you can certainly afford an attorney if you can post the bond of $30,000. But that's just an indication to you as to whatever your strategy will be in the future.
Your Honor, could we also have a one-time return with police?
Yes. If there is a mutual residence, and I'm not ruling who lives where because that's not appropriate, if it turns out that the other person is the person that's going to remain in the residence and you're the one moving, you can return one time with either a deputy or an officer, depending upon where that is, to get your clothing, personal effects, motor vehicle, tools, whatever's involved. It is not the intention of the court to interfere with your life any more than what is required, but what is required is I am required to order you not to have contact with the co-defendant while the case is pending, but one of the two of you will have to move if you actually live at the same location now. Do we have any more requests for adjournment to public defender? The next case that I have is, that person's not here, I believe. It's Ronkia Miller.
Yeah, surety bonded, Your Honor.
Bonded?
Bonded.
Thank you. Christine J. Moore. This is a capias that comes from Division 12. The original charge is burglary of a structure, but the release was revoked back on March the 22nd of 2018. So this is a case from about 15 months ago. Failure to appear for a trial management conference. So it's no bond till you see the judge in Division 12. This is a public defender case. And so your next step would be to talk with your attorney, the public defender, to get a hearing in front of the judge in Division 12 to find out whether that judge will give you a new set of conditions of release. Next case is Jean Louis Negron Maldonado.
I don't have
Nope.
the person on my docket. No, sir.
That may be, that's probably an interpreter case. Spanish. It says Spanish here, so that would be my guess.
That's gonna be good. You need to talk to your attorney about that.
Person's
We
not
can
on
get
my
you out on
docket.
PTR, because I mean, this is one of the situations.
Does anyone know him so that we would know whether he needs an interpreter? It says Spanish on his
Yes.
arrest.
Good afternoon, sir.
There's another case before yours that is, they take the Spanish. So.
Next case is, we'll come back to that. Damian Sierra.
Good afternoon, sir.
This is an arrest affidavit from yesterday, 9917 Hidden River Drive. Count 1, grand theft, third degree of a motor vehicle. Bond's $1,000. Count 2, possession of cannabis, misdemeanor level, $100 bond. Total bond is $1,100. I appoint the public defender to represent you, Mr. Sierra, in Division 14.
Your Honor, we did qualify Mr. Sierra for pretrial release.
And I would note that he has no prior history.
State's position concerning that issue of an alternative to posting bond.
No objection to PTR. We just asked for no contact with the victim.
Okay? You'll need to make that decision on the record in open court as to whether you would prefer to post a bond or be released on pretrial release.
Now, they could do drug testing. Your Honor, after speaking with my client, he does wish to take the PTR.
Okay? It will be somewhat complicated by the fact that his driver's license indicates he's a resident of Hollywood, Florida, which is in Broward, South Broward. But when he filled out his paperwork for, hold on, when he filled out his paperwork, he indicated he lives in Cocoa now.
Yes.
That's Brevard County. Either one is not Orange County. And so you'll need to make sure you understand exactly what the pretrial release program requires of you, even though, you can be on pretrial release if you don't live here, so long as you abide by the requirements. And understand that the problem is sometimes difficult, and if you do violate it, if you do violate the requirements, the judge assigned to the case may put you back in jail. So
Yes, sir.
you need to make sure you understand clearly exactly what they expect of you.
Sir?
The other condition of release is not to be in possession of any substance prohibited by law, and not to have any contact with anyone that's named as a victim or a witness.
Right, and that means you do a county law. So don't do it yourself.
Yeah, my race whatever.
Right now, one's been appointed to
Okay.
public defender's
That's,
office.
yeah, that's
And
fine.
if you hire your own, all they have to do is file a motion in court and if you withdraw. They should have confiscated.
The officer didn't even tell me why I was going to jail until I left, until we left. And then I was like, I'm not going to send a guy, that is yours.
Right now, that's the case right now. You're not going to be able to get in touch with that at the moment. Take this information and talk to your lawyer.
Thank you so much.
Next case is Paul Jeffrey Taylor Jr.
Yes, sir.
This is a warrant that comes from Division 20. It refers to December the 28th of 2018. Failure to update information with the Department of Highway Safety and Motor Vehicles. It comes to me as a no bond, and I appoint the public defender to represent you in Division 20. The state can be heard as to what would be the appropriate bond in this case.
State requests a $3,500 bond.
All right.
Your Honor, I would like to note that according to the police report, and normally our warrant arrest police reports are quite bare of facts. In this case, it does indicate that he responded to 2500 West Colonial Drive. That is the address of the Orange County Sheriff's Office, where the defendant turned himself in when he discovered the existence of this warrant. Given his cooperation, it does seem to be a misunderstanding of the procedures he needed to follow, and he immediately rectified that by turning himself in when he realized he was not in compliance. We'd be asking for a $1,000 bond.
I'd like to look at his prior record.
Oh, yes. Take a look. We don't say anything right now, 'cause this is just for the bond, so you're gonna have a chance to do that.
I'm going to have him sworn in so that he can testify about his connections with the community.
Raise your hand. Do you swear to tell the truth, whole truth, and nothing but the truth, so help you God?
Yes, ma'am.
I would be interested in how long he's lived here and what is his employment.
I've been living here 38 years all my life. I just did 10 years in prison. I just came home last year. Been living here all my life, sir. I never lived nowhere else. I work at a place called Eden Watches, which is my cousin's restaurant. It's on Church Street, right off John Young. It's a car wash / restaurant.
All right.
And sir, they tell me that. Okay.
Do you believe that you were able to post a $1,000 bond, or someone is able to do that on your behalf?
Yes, sir.
Is there an objection by the state to a $1,000 bond?
I'll leave it in the court's discretion.
All right. It is based upon your close ties with the community over a long period of time, even though the prior record is not good. I believe you have a good record of being likely to show up for your next hearing, which is
Yes, sir.
what this is all about. I do set the bond at $1,000 that you can post. I remind you that your address right now is the jail, and when you are released from jail, you must immediately comply with the requirements of reporting to those two locations.
Okay, so I go report back to Orange County?
One is the sheriff's office and one is the driver's license office, and your
Okay.
attorney will talk to you about that.
My ID changed and everything, man.
I mean, you gotta register, yeah.
Yeah, I'll do that.
Okay, that's very important. Otherwise, you're in the same situation. Good day.
This is not, the next case I have is not before me. It's Jatavius Williams.
Mr. Williams bonded, Your Honor.
Thank you. Brian Henry Woodall. This is a driving while license suspended, but it's a charge of a felony because driving while license suspended is a charge where the first one is a second-degree misdemeanor, a second conviction is a first-degree misdemeanor, and a third or subsequent can be charged as a felony. So this has been charged as a felony because it is alleged that you have at least 2 priors. So the bond is $2,500, and I've appointed the public defender to represent you in Division 19. And I think that's Judge John Jordan. Judge John Jordan is assigned to your case. So you can now bond out $2,500 bond, and there's a condition. I order that you not drive until your license is reinstated. Stay in touch with your attorney.
Your Honor, my client here today has an extensive history, but I would note that in his extensive history, he has not had a single failure to appear. We'd be asking for a lower bond given the nature of the charge and the fact that he is likely to show up to court. And we could proffer evidence on the record as to his community ties as well. But he is quite indigent and would be unable to afford even a small bond.
After my review of the allegations contained in the narrative, I'm not willing to release him without posting bond. Someone will have to post bond for him. The only thing I'm willing to do is, based upon his apparent inability to meet the current bond, I will make it, instead of $2,500, I will make it $1,000 with the same condition not to drive. Not to drive while this case is pending. And based upon my prior knowledge of how these work, if you are back in court for driving while this case is pending, I imagine the judge in Division 19 will put you in jail on a no bond status. Kevin Clayton. This is a charge of disorderly conduct as a city ordinance violation from yesterday at Hoffner and South Cimarron. It's a case where it's alleged that you were seeking money from people while standing in traffic. I appoint the public defender to represent you in Division A. It's case number 19MO1139. Is the city making an offer to resolve the case today?
Adjudication 3 days.
Your Honor, after speaking with my client, he does wish to enter a plea of no contest as to the charge in exchange for the agreed-upon plea of adjudication of guilt, 3 days, Orange County Jail, credit for 2 days' time served.
All right. What's your full legal name?
Kevin Alexander Clayton,
Date of birth?
9/27/99.
All right. How do you plead to the city ordinance violation of disorderly conduct?
No contest.
Do you have any questions you want to ask me concerning the charge, the facts of the case, the plea that you're entering, or the proposed sentence?
No, sir.
Are you satisfied with your attorney?
Yes, sir.
Did you read and understand and sign your plea form?
Yes, sir.
Approximately how long have you been in the Central Florida area?
My whole life.
Okay. You understand then how dangerous that intersection is for someone wandering around among cars?
I wasn't wondering, sir.
A lot of people don't obey the traffic signals there, and it's very easy to get run over. And so part of the reason for this type of enforcement is for your protection. But it's also to protect people that are driving, because sometimes they can't tell the difference between a request for money and a demand for money. Okay? I accept the plea at this time. You're adjudicated guilty of disorderly conduct, a city ordinance violation. The sentence is 3 days, credit for 2. You'll be released later on today, and I'll order you not to go back to that location during the next 78 days. The court costs will go into civil judgment. This is Jose Damian Cruz.
Yes, sir.
It's an arrest affidavit from yesterday for camping, city ordinance violation at 400 East South Street. The public defender is appointed to represent you. The case number is 19MO1140. There may be an offer to resolve the case today from the city.
Adjudication 3 days.
Talk to your attorney about whether it's best for you to enter a plea or to bond out. Your bond's $500.
Your Honor, after speaking with my client, he does wish to take the offer and enter a plea of no contest.
All right. What is your full legal name
Said Damian Cruz Rodriguez,
and date of birth?
6276, sir.
The charge is a city ordinance violation of camping where prohibited. How do you plead?
No contest?
Are you satisfied with your attorney?
Yes, sir.
And did you feel like you had enough time to decide what's best for you?
Yes, sir.
Okay. Any questions you have for me?
No, sir.
I accept the plea at this time. You're adjudicated guilty of a city ordinance violation. Sentence is 3 days, credit for 2. You'll be released later on today. I order you not to return to 400 East South Street during the next 178 days. Your court costs will go into a civil judgment. Serena K. Tinsley is the next case.
Yes, Your Honor.
This is a city ordinance violation from Jackson and Terry from yesterday. You have not requested a public defender. The case number is 19MO1142.
The offer is adjudication 3 days.
All right. It is a case where The phrase usually used is just suspicious activity. It's the Shiloh Baptist Church. An air conditioning unit at the youth center, and it wound up being a city ordinance violation. You have not requested an attorney. Are you going to represent yourself today?
Yes, sir.
How do you plead?
I'm not guilty, sir.
Okay. And are you planning to bond out?
No, sir.
Do you think it might be best to request a public defender to assist you?
That'll be just fine, sir.
Okay, but you do not want to enter a plea today, is that correct? I'm trying to find out, I'm not certain as to what you want to do. If you decide to enter a plea of no contest, you will not be admitting any facts, but the sentence will be 3 days credit for 2, meaning you'll be released later on today.
Yes.
So that's one possibility. The other is you would have to bond out on a $250 bond, and if you're not able to do that, you'll still be here. So would you like to talk with the public defender, even though I have not appointed the public defender? That person would be willing to give you advice at first appearances if you're not sure what is best for you.
Your Honor, I'd like the first choice because my money was thrown away with all my food and my clothes by the
Okay.
officer that busted my
Okay.
knee and broke my foot.
And so you are going to
And
enter?
allowed 2 other gentlemen that were walking through the church to walk away and leave.
Okay. Do you think it would be best for you then to enter a plea of no contest?
Yes, sir, I do,
Okay.
Your Honor.
I want you to read and sign this plea form then.
I read it. I have a copy outside.
All right.
And I read it. It was given by Officer Anderson. Thank you.
What is your full legal name?
My full legal name is Serena K. Tinsley, which is
And
printed
your
on my
date-
credit card.
And your date of birth?
My date of birth is June 12, 1975.
Okay. And am I correct that you are entering a plea of no contest to the city ordinance violation?
Yes, sir.
I
Your
accept-
Honor,
I-
thank you
I
for the
accept-
advice from you, the courts, the city, the state.
I accept the
And
plea
the
at
public
this
defender,
time. You're
even
adjudicated
though-
guilty of a city ordinance violation. It is 3 days credit for 2. You'll be released later on today, but I'm going to order you not to go on the property of Shiloh Baptist Church, 604 West Jackson Street during the next 177 days. The court costs in this case will go into a civil judgment.
Understood, Your Honor. Thank you, sir. Thank you. Good luck. Thank you so much. Thank you to the courts. Thank you. Thank you.
Isabel Emily Badeau?
Yes, sir.
This is a charge of petty theft, the first arrest affidavit, a retail theft charge from 10500, which is the address of a Walmart store from yesterday. The bond is $250. The second arrest affidavit is for false report to a law enforcement officer from the same time and place, and it has to do with giving personal information to the officer. Bond is set at $500 on that case. The public defender is appointed to represent you on these 2 misdemeanor charges.
We qualify Ms. Biju for pretrial release.
No objection to PTR.
All right. I want you to talk with your public defender, Mr. Jordan, who's standing next to you, about your option here. One possibility is to bond out. The other is if you feel you're not able to accomplish that and you're willing to obey the requirements of pretrial release, that would be an alternative so that you would not have to post any money to get your release. Either way, I'll order you not to go back to that Walmart while the case is pending.
ETR, could you confirm, I see one misdemeanor, but I'm not seeing any. Oh, that's a juvenile conviction? Okay.
Should be making telephone calls from our once a month, so you'll be on telephone with court pre-trial.
Your Honor, after speaking with my client, she does wish to proceed with the pretrial release.
All right. So it is pretrial release on both cases with a no return to the Walmart store while the case is pending. Next case is Charles Kenneth Jordan Jr.
Your Honor, may I have a moment to speak with the state before we start? Doing indecent exposure for urination.
Oh, all right, that's fine.
Your Honor, I do have argument for probable cause in this case after speaking with the state.
State had no objection to ROR, Your
They had
Honor.
no objection to ROR.
All right. The bond that's listed is $500.
Charles
and,
Jordan?
based upon the.
Nope, sir, just a second. Charles Jordan,
Charles Jordan's in the hospital, Your Honor.
hospital. I'm sorry, Your Honor.
Okay. Do you still want to have that changed for him?
Yes.
I have no objection
No
to you being
objection.
not present.
I'll make that change. I'm not able to see him yet, but today I make that change to ROR on that charge, so when he is out of the hospital, he will not have to post bond, but reset for tomorrow, first appearance. Next case is Trevor Alex Manson Lombardo.
Yes, sir.
This is a disorderly conduct charge from yesterday at 4524 South Orange Blossom Trail.
I'm sorry, Your Honor. Could I have a moment to speak with the state on this one as well? 2 in a row.
No objection to ROR.
Yeah, it is a scant police report, but if the state has no objection, we'd like to see this ROR.
All right. This case will be an ROR with a condition of no return to the Family Dollar Store at 4524 South Orange Blossom Trail. No, it's just by agreement between the state and the defense.
Now, is public defender appointed?
Yes, in this case, the public defender is appointed to represent him, Division A.
Okay, sir. Any questions?
Both of those are agreement.
Happy day. Good luck.
Thank you, sir.
Terry Philliston.
Yes, Your Honor.
Is this a misdemeanor?
It is
offense?
not.
Okay. So it's a felony fleeing to elude?
An F3, yes.
Oh, all right. I appoint the public defender to represent you on a charge of fleeing. It's from 8107 Vineland Avenue. It's Division 19, and I'll give you the case number. It's 19 CF 8396. The case comes to me as a no-bond case, but I'll be setting bond today. That bond is based upon the facts that are set out in the Florida statute for fleeing. I am to consider whether he was driving a vehicle, did he endanger himself as the driver, did he endanger any passengers, did he endanger any other drivers or pedestrians, was there a crash, were there injuries, did he exceed the speed limit greatly, was there reckless driving, did he run a red light, did he run a stop sign, was he fleeing a more serious crime, and has he been convicted in the past of fleeing? And finally, his general criminal history. The state may be heard as to the argument as to what the bond should be in this case.
They request $3,500 bond.
How much?
$3,500, Your Honor.
Thank you. Defense can be heard if that's not appropriate. It sounds appropriate to me based upon the allegations.
Your Honor, may I have a moment to speak with my client?
Yes.
Your Honor, I believe the initial attempt at stopping him was conducted by a officer on the sidewalk in front of a business. The allegations in the police report are that he drove at what they describe a high speed for a parking lot. There was no posted speed limit in which he breached. And further, I do not believe at any moment he endangered anyone on the scene. The officers were not in the road at the time when, according to the police report and the facts in the report. I would also note that he does not have any criminal history, no convictions, no misdemeanors, failure to appears in the state of Florida. And as such, we would ask for a lower bond be set, given the facts in this case.
I find that based upon argument of counsel and the allegations contained within the narrative, that the bond in this case will be $2,500. No return to the Orlando Premium Outlet Mall, 8200 Vineland Avenue, while this case is pending. No contact with any person that's named or referred to as a witness to the charge. Public defender does represent you in Division 19.
Okay, sir. Lower the bond. You can bond out today. Okay, keep in contact with you.
Next case is Melissa Vasquez.
Talk to you again. One has been appointed to you. Melissa?
Cody.
This is an arrest affidavit from yesterday at 2756 East Colonial Drive, trespass on property after warning. This is a Ross store in a shopping area. The public defender is appointed to represent her. The bond on the case is $500.
Briefly, Your Honor, I think my client needs headphones. She's hard of
Okay.
hearing.
All right.
So we're going to get some hearing aids.
I'm sorry, sir.
No, don't apologize. Don't apologize. You're fine.
I just have really bad hearing.
apologies, Your Honor. Let me-
Thank
Okay.
you.
All right.
That's better.
The charge from yesterday is trespass on property after warning at the Ross Store, 2756 East Colonial Drive. The bond on this case is $500, and I've appointed the public defender to represent you. The condition of release would be not to return to that entire shopping center area located at 2756 East Colonial Drive. The case is complicated by the following.
Your Honor, briefly, I have received from the state an offer to resolve.
And is that offer made with the knowledge that she was out on bond on 2 prior cases?
Yes, Your Honor.
All right. And what is the offer on this case? On the
Adjudication, 4 days, no return. 4 days?
And what would be the state's approach to the handling of the 2 prior cases that presently hold her without bond?
If she resolves it, no action. If she doesn't, revoke and double the bond.
Okay. I want you to talk with your attorney about your options today, this morning.
Okay, sir, thank you.
Your Honor, after speaking with my client, she does wish to accept the offer and enter a plea of no contest in exchange for the 4 days adjudication.
All right. What is your full legal name?
Melissa Marie Vasquez,
And what is your date of birth?
7/23/75.
Did you read and understand your plea form?
Yes, sir.
How do you plead to the charge of trespass after warning?
No contest.
Did you have enough time to talk with your attorney about your options today?
Yes, sir.
Are you satisfied with the services rendered to you by the Office of the Public Defender?
I am, sir. Thank
I
you.
accept the plea at this time. You're adjudicated guilty and the sentence is 4 days, credit for 2. I order that you not return to Ross Department Store or any of the surrounding area within 500 feet of that store at 2756 East Colonial Drive. That no return is during the next 350 days. The court costs are payable within 350 days from today. The 2 felony charges for which she is bonded back in May, grand theft 3rd degree on each case. The hold is lifted at this time and no further action is taken. Make sure that you make each and every hearing date for those 2 prior cases because they are felony charges.
Yes, sir.
And you're facing serious charges there. And it indicates here, it says, where it says PD or attorney name, it says not applicable. Is she represented by an attorney on those cases, as far as we can tell? Would
I
it
need
be,
one.
would it be in her best interest for me to appoint the public defender today on those felony charges based upon this new case is gonna affect those?
I showed that there was the PD, but if that is not the case and I'm mistaken, I would ask the court to appoint the public defender.
Does it show? Okay, according to our records then, she does have the public defender, even though it doesn't say that on the Corrections Department paperwork here. So you do have the public defender, so get in touch with your public defender.
Okay.
You want some information on that? Let me give you your case numbers as well. No, it doesn't, I don't know if charges are filed yet. Let me just give you some information on those, but you will be able to leave tomorrow and you took no action on those bonds, so. Tomorrow. Mhm. Mhm. I know, don't ask me about it, please. Take your pick. Morning, sir.
The next case is, State of Florida, it's Lewis Wyatt Branson.
Yes, sir.
This is an out-of-county warrant. It says that it's Judge Boatwright in Putnam County. And seems to me that would be Palatka.
Yes,
Does
sir.
that sound, that would be you then?
Yes, sir.
Okay. It states that there is a bond, so you can bond out if you're able to. The amount of bond is listed at $518. Ordinarily, that would make me think that maybe the case is already, it's already the back end of the case, and that perhaps something hasn't been complied with or something like that. But anyway, you can bond out here, and then it would be up to you to show up to the right courthouse in front of the right judge and so on. If you do not bond out, or you choose not to bond out, Putnam County is supposed to pick you up within 72 hours of being notified.
Okay.
All right? This is Melissa Grace Eisenberg.
Yes, sir.
This is a warrant from Volusia County. It indicates it's for domestic violence battery with a bond of $500. And so Volusia County will come and pick you up within 72 hours of being notified, and you'll see a judge there. It doesn't say where it is. I know that there are courthouses in DeLand, New Smyrna,
Deland.
Halifax Center in Daytona, and so on. But, so if it's DeLand, wherever you're supposed to go in Volusia County, they will transport you there. But it does say that you can bond out on a $500 bond. If you choose to do that, then it's up to you to go to the right place.
So I could bond out here?
That's what it says. I'll find out from the jail whether they have anything that indicates she cannot. You can bond out here on a $500 bond, and then you start all over again with whatever your requirements are.
Okay, thank you.
Quentin Wright.
Yes, sir.
This is a probation violation case. The arrest took place yesterday at 27 Coburn Avenue. And it is from Lake County. It indicates that you were placed on probation for 2 years on January the 17th of 2017, and that it was modified on July the 26th, 2018, to be on probation for 4 years. The allegations are committing new crimes here in Orange County, violating Condition 5 and 7, violating condition number 5 of the probation. And then there are 2 technical violations. One, being in possession of cocaine would violate condition 7. and that you haven't paid your cost of supervision. So once there are no Orange County cases holding you, you'll be transported to Tavares, to the Lake County Courthouse to see the judge there assigned to that case. So all I can do is advise you as to what this paperwork indicates, and that's what I've just done.
Yes, sir.
The final case of the first session is Cassidy McDonald. I did appoint the public defender to represent Cassidy McDonald, even though I was not able to see her until today. This is the second part of the first appearance. I'm advising you that on June the 9th, you were arrested at 1201 North Cimarron Boulevard on a felony charge of possession of cocaine with a bond of $1,000. There are also 2 misdemeanor charges, possession of drug paraphernalia and possession of cannabis, each having a bond of $100. So your total bond, $1,200. You have the public defender, and it is, which number would that be? It's DKB? It's Division 11. Who is it? It's Judge Beamer in Division 11. You have the public defender. It's a $1,200 bond and a condition that you not be in possession of any substance prohibited by law while the case is pending. Thank you. You're so good at that, maybe I should move it down. We'll now proceed with 33-day motions.
I think they're in courtroom 2, Your Honor.
Very good.
That was my email I got today. Yes.
No objection.
Now, it is a 11:15. What time do the state and the defense prefer to come back for the second session?
I'll lead up to this defense within
Okay.
reason.
How long would you prefer to have?
30 minutes, Your Honor, would be fine. Does PTR need additional time? Okay.
Okay, so we'll come back at 11:15?
Yes, Your Honor.
Yes, Your Honor.
All right. We're in recess until 11:15. This is the beginning of the second session in courtroom 1. This is Tuesday, June the 11th, 2019. The first case to be reviewed is Gregory Campbell.
Yes.
It is a violation of probation warrant that comes from Division 14. The original sentence was on June the 8th, 2017. The supervision length was for 5 years, so I do find jurisdiction. The judge reviewing this case and signing the warrant ordered no bond, so you are being held until you see the judge in Division 14. Are you planning to be represented by a private attorney?
I guess.
Your plan is to hire a private attorney?
Yeah, I guess.
All right.
Actually, no. I wouldn't need an attorney, actually.
Okay, well, the decision is up to you. However, I would point out that almost all persons charged with this offense either hire a private attorney or request a public defender to assist
Request a
them you think it might be best to request a public defender?
Yeah.
Okay. I do not have an application from you yet, so I'm going to ask you some questions. Do you recall filling out an application this morning?
No.
You would have a pink copy if you did.
No, I didn't.
Okay. At the time of your arrest, did you have a permanent job?
No.
Do you have any property that you would be able to sell if you had to pay a private attorney, such as a paid-for automobile?
No.
Okay. And what is the source of your income generally? Do you
Sounds-
receive Social
SSI.
Security or
Yeah.
anything like that? Yes?
Yeah.
What would be the average amount that you receive a month from any
700.
source?
700 and around 700.
Okay. I'm going to appoint the public defender to represent Gregory Campbell in Division 14. He's being held in no bond on a 5-count violation of probation. They appear to be five technical violations having to do with being discharged from a program, being in possession of substances prohibited by law, and so on. The case number is 17 CF 4773. No bond.
Good morning.
This is Jaleel Javier Cobbs.
Yes, sir.
This is a warrant arrest affidavit. The warrant itself refers to the date of January the 26th, 2019. The charge is listed as second-degree murder with a firearm. Judge Jeffrey Ashton has signed this warrant indicating no bond, may not be modified at first appearances. The public defender is appointed to represent you in Division 22. There is a notice of invocation of constitutional rights attached to the file. Stay in touch with your attorney concerning this case.
Yes, sir.
Your Honor, we would also ask that he's have no contact with any co-defendants, no victims, no witnesses, no weapons or firearms if he is ever to be released.
All right. In all criminal cases, there is a requirement that there be no contact, but we emphasize this by stating in particular what is involved. So since you're being held on no bond, it would have to do mostly with visitation and telephone. But the law requires no contact with anyone that is named or referred to or thought to be a victim, witness, co-defendant. And there would be an additional condition of if you do receive an opportunity to be released, you would not be in possession of any substance prohibited by law, and you would not be in possession of a weapon, including a firearm.
Yes, sir.
All right. This is Andre Ramon Jenkins.
Yes, sir.
This is a an arrest affidavit that's connected to a traffic ticket. The charge is driving while license suspended, but it's charged as a felony due to the fact that it's alleged that there are 2 prior convictions. Each time a conviction occurs for driving while license suspended, it makes the next one a more serious offense. And this one winds up being a felony now. The bond is $2,500 on that charge. There's an additional charge of grand theft of a motor vehicle, and it has a bond of $500. The correct bond for that count 1 should be $150. The third charge is a misdemeanor, resisting without violence. The bond on that case should be $100. So your total bond is $2,750. I appoint the public defender to represent you in Division 12 on those charges. They come from Lime Bay Drive and Billingsgate Road from yesterday. The next case is a warrant, and the warrant refers to May the 26th, and it's a charge of petty theft, but it's charged as a felony because it is alleged by the state that you have 2 prior convictions for petty theft. That is also a type of case where multiple convictions will increase the level of the charge. It indicates from that, Judge Allen has ruled that your bond is $1,500 for petty theft with 2 prior convictions. I appoint the public defender to represent you in Division 17 on that case. The next case, also, I ruled that the prior petty theft charge that was holding him without, that no actions be taken on that and the hold is to be released. There's a third charge, and it is from early this morning, a little after midnight, at 2023 Whitby Drive. The charge is grand theft 3rd degree, and after reviewing the 2 prior cases and the allegations of this case, I set the bond on this charge at $1,500. It is in Division 14, and I appoint the public defender to represent you in Division 14. It will also have a condition, no return to the Dillard's Department Store, 8001 South Orange Blossom Trail, which is the address of the Florida Mall. So no return to the Florida Mall or the parking lot or the hotel or any of the surrounding areas within what is called the Florida Mall while this case is pending. You do have the total amount then for bonds. You have on the first case, $2,750. Second case is $1,500. Third case is $1,500. You have the public defender on all cases. This is Lanice Jenkins.
Yes, sir.
This is an arrest affidavit from earlier this morning at 4439 Prince Hall Boulevard. I've appointed the public defender to represent you on this particular arrest affidavit. Count 1 is resisting an officer without violence. Count 2, possession of drug paraphernalia. Count 3, trespassing. These are 3 second-degree, these are 3 misdemeanors. The first 2 are first-degree misdemeanors. The last one is a second-degree misdemeanor. Your bond is $700 for those 3 charges, 500, 100, 100. There would also be a second arrest affidavit before me, and I appoint the public defender to represent you in Division 16 on this case. Count 1 is possession of cocaine, $1,000 bond. Count 2, introducing contraband, that's also a felony, bond $150, for a total of $1,150.
Your Honor,
Yes.
we are requesting that the charges be treated as subsidiary, given the fact that the police reports are nearly identical and the events occurred during the same criminal incident.
I'll hear from the state. I note that the second affidavit comes 3 hours after the first, even though they are connected by the initial arrest. What's the state's position as to whether these 5 could have been placed into one affidavit? That's basically the test. Would ordinarily we expect to have all of them in one affidavit, or should there be 2 affidavits?
No objection to one affidavit, that's fine. So treat the 4915 as a subsidiary accounts.
All right. The effect of that will be that the possession of cocaine in case number 2019 CF 8391 will now be a bond of 150. Total bond then on all charges. No, actually,
I believe that.
it should be the resisting without violence will be 150. No, it will be 100. Let me get this right. On the arrest affidavit that occurred at 241, it will be 100 on each of the three charges. Then the bond on the possession of cocaine will remain at 1,000. The total bond then is $1,450 would be the correct bond for 5 charges, as if they were in one arrest affidavit, and the possession of cocaine would be the principal charge listed. Public defender represents you in all matters in Division 16 and Division A.
You're gonna have to talk to a bail bondsman.
Okay.
This is Adine Mann.
Sir.
This is a warrant arrest affidavit for violation of probation. It indicates here that in Orange County, you were sentenced on February the 21st, 2018, on the charge of trespassing and stalking. I see in reviewing the paperwork that Judge John Marshall Kest did sign this warrant. He signed it on May the 24th of 2019 and ordered no bond. He found probable cause, and I am not allowed to go behind that. I do note that on the face of the paperwork, if he was sentenced on February the 21st of 2018, and the warrant was signed on May the 24th of 2019, that was beyond 1 year. So unless these two were consecutive sentences, one to follow the other, it does raise a red flag, but that's to be brought up before the judge assigned to the case. If they were consecutive, ordinarily, whichever one followed would be the only one that is the subject of the violation, rather than the first one. It would have already ended. It would have already ended on February the 20th at 11:59 p.m. 2019. But again, Judge Kest is the person that knows, has the file and knows why he found probable cause, but that can be raised thereafter. I don't have an application from Mr. Mann. Are you planning to hire a private attorney, Mr. Mann?
I have one already, yes, sir.
All right. Advise your attorney what I just said, that can be raised. All right? Division 20.
Look, sir.
This is Danielle Thomas. This is an arrest affidavit from yesterday at 8350 South Orange Blossom Trail. It's count 1, burglary of a structure, bond $3,500. Count 2, possession of fentanyl, $150 is the bond. Count 3, grand theft, bond $150. And finally, a misdemeanor, possession of drug paraphernalia, bond $100. Your total bond, therefore, is $3,900. I also order that as a condition of release, you have no contact with anyone named as a victim or a witness, and no return to 8305 or 8302, which are residence addresses involved in this case somehow, and no return to the Best Buy store located at 8350 South Orange Blossom Trail while the case is pending, including its parking lot. The public defender represents you in Division 16. This is Thomas Levon Rodney.
Yes, sir.
This first matter is a warrant arrest affidavit, and it has 7 charges on the front page, together with an 8th one on the second page, a total of 8 charges. And count 1, trafficking in a certain level of meth, and it has the bond listed as what would be the mandatory fine upon a conviction, and it's listed as $100,000. I believe that under our system, all of the counts 2 through 7 should have bonds as subsidiary cases, and so I will make a change on those. Is the state in agreement that,
No objection, Your Honor.
all right?
Thank you, Your Honor.
So I'm going to go through those. Each one that's a felony will have a bond of $150, and each one that's a misdemeanor will have a bond of $100. And as I look at those, I believe each one is in fact alleged to be a felony. And so counts 2 through 8 will each have a bond of $150. Therefore, your total bond is $101,200. Although that can't be. I'm a little off. It's close to that, but it'll be 7 times 150. So it's going to be $1,150. $101,050. 050. Okay, we got it. There is a second, and that's public. Are you planning to hire a private attorney?
I already have a private attorney.
All right. That first warrant arrest affidavit is in Division 22. And the date that's shown in that warrant is April the 20th. The second warrant is Division 80, and it's for violation of county court probation. The original sentence was for driving while under the influence with a prior conviction. It was for a term of 360 days, and it was August the 3rd of 2018, so I do find jurisdiction. And it was concurrent with the charge of reckless driving reduced from DUI. There are 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11. There are 11 paragraphs concerning violations, and so you and your attorney will want to go through those individually to make a determination as to how you're going to defend those cases. Some of those are caused by new charge. Some of those are technical violations. But that's a no bond case until you see the judge assigned to the case, Division 80. There is also, yes. So because there was a sentence for driving while under the influence and a sentence for reckless driving, even though they're going to look identical, those are two different violation of probation cases. So that you know you have two cases in Division 80, violation of probation, no bond, plus you have the new charges.
So it's two violations? There's two violations?
Well, when you have two cases of probation, you're under supervision for two different cases, one problem can create a violation of both those at the same time, because they're running at the same time.
Oh, yeah?
So talk to your attorney about how that works. Right. David Seacrest Weeks. He will be rescheduled for tomorrow for first appearances. Jamel Whitehead.
Yes.
This is an arrest affidavit from yesterday, from this morning at 4:17 this morning at Washington Street and Orange Avenue. The charge is robbery. This case has a bond of $10,000. The public defender is appointed to represent you in Division 17. There's a second charge of resisting an officer without violence, which was about 50 minutes earlier than the robbery charge. The bond there is $1,000. What is the state's position concerning the bond on each of those two affidavits as to whether the present bond matches up to the charge and/or should the two be in one affidavit with a subsidiary bond rather than a full bond?
No objection to the 19 MM4914 bond being $100.
And is $10,000 the standard bond for robbery?
I'm checking, Your Honor.
All right.
Not if there was no weapon involved.
It appears to me that it was a tussle between various individuals. One throws a can of tuna and the other takes some $20 bills.
Robbery by strong arm, sudden snatching.
It's a $5,000 bond on the bond schedule.
On the bond, well, it depends.
It's charged as 2C. It's $5,000.
Robbery, strong arm by sudden snatching, is it 2B or 2C? 2C. Then $5,000 is the, according to the bond schedule.
It appears to me that the allegations are that the victim did get punched. I would say that $5,000 would be appropriate, taking everything into consideration. So at this time, I do set the bond on the robbery charge at $5,000. And I set the bond on the other charge, misdemeanor of resisting without violence, to be $100. Your total bond, Mr. Whitehead, is $5,100.
We ask for no contact in the weapons.
No contact with anyone that's named or referred to as a victim or a witness, and there is a victim and witnesses, and no, not to be in possession of a weapon, including a firearm, while the case is pending. John H. Fisk. This is a Florida Uniform Traffic Citation, a traffic ticket at 1678 Orange Blossom Trail in Apopka, but it became an affidavit for driving while license suspended or revoked knowingly, a bond of $500 in Division A. I've appointed the public defender to represent you on the charge. Your case number is 19 CT 708 AA, meaning Apopka Courthouse. If you had bonded out, that's where you would go. The other condition, in addition to $500 bond, is not to drive until your license is reinstated.
Does the state have an offer in this case?
No.
I don't believe that type of charge can be resolved at first, should be resolved at first appearance. And based upon the reason for the suspension, you will need to post a bond of $500.
Up for $50?
Yeah. $20%? Or is it minimum?
Adrian Abel Diaz Torres. All right, we'll reschedule that for tomorrow. Marcus Harris. This is a warrant from another county. It's from Osceola. So you'll be, if you have no Orange County cases, you'll be taken down to Kissimmee to see a county judge there. The case is originally driving while license suspended, but this is for failure to appear for arraignment. And the judge there set the bond at $2,999. And that's a characteristic of Osceola County, is they like to put a particular number showing which judge it is, but I forget who it is. But anyway, you'll go down there either today or tomorrow to see a judge, and that judge will have the file.
If you don't get
The judge that used to do that is retired, so I don't know who it is now. All right, this is Kashera Terry.
Yes, sir.
This is a warrant that comes from Sumter County. Is that Wildwood? Does that sound right? Sumter County?
I think it's Leesburg. It say Leesburg on the paper.
Actually, Leesburg's in Lake County, but this says Sumter County.
Yes.
It indicates its possession of, it's a felony level violation of probation
Yeah, I see it.
in Sumter County. So all I can tell you is that if you have no Orange County cases, they will come and pick you up within 72 hours. If it was Lake County, if it actually was in Leesburg, it would be at the Tavares Courthouse in Lake County, and they would pick you up within 24 hours. But this is not a contiguous county. Sumter's on the other side of Lake County. So they have 3 days to pick you up, and they'll transport you there to see the judge, who will have the file. And I don't have a file. All I can do is inform you of this situation. Okay? This is Alagre Ramjelis.
Yes, Your Honor.
And do you also go with the last name of Rodriguez?
Andel Rodriguez.
Okay.
Yes, sir.
All right. This is a warrant for violation of probation. The original sentence was June the 20th of 2016. and it was for a term of 2 years of community control, followed by 1 year of probation. Judge Dan Traver in Division 15 ordered that you be held without bond, and so you'll see that judge. Original sentence was for possession of cocaine and aggravated battery. And these are, let's see, there is a technical violation having to do with moving, and there's a technical violation for not reporting. And then finally, there is also an allegation of a new charge in Pinellas County of domestic battery, August the 14th of 2016. So you're being held without bond. I don't have an application from you. Are you planning to hire a private attorney, or do you think it would be best to request a public defender?
I'm gonna hire a private attorney.
All right. There's a second matter. And so that first case is, that's Judge Traver in Division 15. There's a second matter that's in front of Judge Kest in Division 20, and that's a violation of probation. The original sentence was aggravated battery with a deadly weapon. And that's also in no bond status, and you'll see that judge. It's the same 3 matters that are concerning, but it's 2 different probations. So you'll see those 2 judges next. Both of those have no bond, but you and your private attorney can request bond when you see the judge assigned to the case. All right? Okay, I believe that concludes our session.